real estate developers build and consumers buy. But if there are disputes of specifications, dates, sizes, prices, etc., there's really no easy means of resolving the consumer's plight. Today, we bring you expertise of India's top legal minds to get unbiased advice on how to resolve some of these. Sunil Tyagi, Senior Partner, US Law, joins us. And we've got our first caller. Sunil, thanks very much for joining in. Let's go across to Mr. Vijay Kumar. Mr. Kumar, go ahead, sir. How can we help you?
Yeah, thank you. So probably I'm related to possession, where I got all the formality done from the builder, and I have some penalty as well because that project is delayed by the builder, and they have also charged some interest of delay payment. Okay. So while the agreement, they do have the many documents, and I also signed that if there is any delay in the payment, they won't going to pay the penalty for me. So my question is, is that really ethical?
That's not at all ethical, Mr. Kumar. That's not at all ethical. Sunil, what does he do? I mean, where is this? Is there any justice, a buyer-seller agreement saying, hey, we can delay for 2 years? But if you delay, we don't even have to pay you penalty. We can not only slap you with interest, but our penalty which is due, we don't get to pay that as well.
As we know, most of the builder-buyers agreement, they are one-sided agreements. But repeatedly, the courts have held that in case there is a delay by the developer, similar penalty as is imposed on the buyer will be imposed on the developer also. So whatever interest builder is charging from you, similar rate of interest, he is liable to pay in case there is a delay from his part. So even if it is not provided in your agreement, you can always recover
I think, Mr. Kumar, please go to the court. If you've taken a stand of not paying because the project has been delayed, I think there's nothing wrong with it. Sure, if now you want to settle out, then really you have to pay an interest, and he also has to pay an equal amount of interest, not the interest which is written in the agreement, which is just what, 5 rupees per square foot, which works out to 3 or 4%.
Yes, it's not 5 rupees per square foot per month, which is generally written in the agreement.
Yes, absolutely. So please go to the consumer court, and I think there's been a precedent, so you should get some justice there. Nagraj writes in and says, I booked a flat by paying 30,000 rupees to Tata Value Homes. I've not made any agreement with the company, but with a personal problem, I'm not able to make or purchase the flat. I'm asking the developer for a refund of the amount, but he's saying no. Well, legally, they're in the right, isn't it?
I presume that he must have filed some application for booking. Generally, the practice is in application also it is provided if you cancel it for any reason which is not attributable to developer, some part of the money as earnest money is forfeited by the builder, and which has been approved by the Supreme Court also. And if there is a contract which provides for forfeiture for backing out of the contract, he can forfeit that money. So I presume in your case, if in application form it is provided and you have agreed to that term and you're backing out of the contract for no reason, for no default of developer, your money, some part of it can be forfeited.
Can be cancelled. And I think it's only fair because the developer is saying that, hey, we could have actually, we might have had another buyer, we could have given him the flat, but now where do you go out and there? And in a downtime, if there was a queue of buyers, I guess the developer would even make an exception, but there is no queue of buyers, so he's not, and legally he's on the right. All right, Nilesh Tiwari, we're going to take this question as well. I purchased a 2 BHK flat of 880 square feet area in Ajnara, Lagarden, Noida extension. I would like to know your expert inputs on builder has included lease rent in my basic selling price under construction link plan, whether this should be included in BSP or that's a basic sale price, or is it paid at the time of possession, and is it supposed to be paid to the builder at all? Now, according to me, this was never actually quoted as a separate price, Sunil. It was always part of BSP, but I'm thinking what the builder is trying to do here is trying to show the BSP as a lower price and then asking him to pay the lease rent which the builder owes to the authorities, isn't it?
This could be one of the reasons, Manisha, but at the same time, there are different ways the developers are paying lease rentals. Some builders are paying upfront one-time lease rental to the Noida authority, and some are opting for paying it in installment. And generally the balance money they pay at the time of completion to the authority. So in case the builder has paid only part lease rental and part he's paying at completion, he will charge you on the basis at the time of the completion of the project. At the time of possession, then he knows his exact liability.
Okay.
But if somebody has paid upfront, then he knows his exact liability, what he has paid to the authority, then he can charge initially also from you.
Right.
So this is more kind of a market practice rather than a rules or regulation where it is provided when to charge. There's nothing wrong in this.
Absolutely. So don't be concerned about it. There's really nothing wrong in the builder charging you. You need to calculate the total overall price of the project or the flat and say, hey, does this make sense for me or not? Sunil, thanks so much for coming in. I know we've only had time to take 3 questions, but these are all important questions, especially in times where all buyers are wondering and thinking whether they should go ahead with real estate or not.